Robbery. But the state cuts a deal to a lesser charge. 4 years deferred probation. Judge West wants a pre-sentence report first. Is this a second chance or a trap? One wrong move and that deal disappears.
Judge, on this case, with the court's permission, we're going to proceed on the lesser included. He has agreed to some stipulations that I would rather not put on the record. It's court can read between the lines on that.
Sure.
And also the co-defendant, for your information, was in custody in Orange County on a motion to revoke, I believe, a misdemeanor one. I've spoken with the prosecutor over there. It's my thought that probably Ms. Holmes let me know Louisiana has since picked him up, that they probably led him to credit the time on that MTRP, and Louisiana grabbed him before we could grab him back. And that may ultimately dispose of the entirety of this case.
All right, sir, you're Devon Murray. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Murray, in cause number 26 DCCR 0346, the state's elected to proceed on the lesser included offense of robbery from January 15th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? You fully understand them. And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, have no contact at all, communication with the co-defendant, and that's Lugo?
Jesus Lugo.
Jesus Lugo. You understand?
No.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murray's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser offense of robbery freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you in the case, and then we'll come back later for sentencing. So based on all of that, Ms. Malfino, what's the state's position with regard to a reduced bond?
The state is in agreement with that, Your Honor. He does not have any criminal history to speak of other than a possession of tobacco lab. All the criminal history is really associated with his total history with that.
All right, so he's pleading.
No, I know.
Okay. So what I'm going to do, Mr. Murray, based on the nature of your plea agreement, is reduce your bond in your case to $1,500. If you make that bond, it is important that you understand a condition of that bond is to have absolutely no contact or communication with Jesus Lugo, and to do everything you're supposed to. Go straight to the probation department. If you get released, get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. If you get arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. So it's very important, if you make that bond, that you get out, you do exactly what you're supposed to, go straight to probation, and then we'll see you back here at sentencing. All right? You can go back with the bailiff.
Sexual assault of a child. Deferred probation. Then defense drops an 11th-hour habeas corpus bombshell, 2 hours before sentencing. Judge West is not amused. Will she let the hearing proceed or slam the brakes? Watch her shut it down.
Good morning, ma'am. You're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder's here with her attorney, Mr. Bynum. Ms. French is here on behalf of the state. Ms. Magruder is on probation in cause number 16-25158 for the second-degree felony offense of sexual assault of a child. Was placed on that probation January 29th of 2018. We were previously in court and Ms. Magruder entered pleas of not true to counts 1 through 5 of a motion to revoke unadjudicated probation. Case was set for hearing today for sentencing. I have received and reviewed the pre-sentence updated report. Have you both had an opportunity to review that report?
I have, Judge.
Yes, Your Honor.
Are there any corrections to that report?
None from the state, Your Honor.
Judge, I would like to make some objections to the report, but if I may, I'd like to also point something else out to the court. This morning, I filed a application for a writ of habeas corpus under Article 11.072 in this case, and I have a courtesy copy for the
I
court.
have a copy
Okay.
of it.
So
I don't think this is the appropriate time for that because Ms. Magruder is on a deferred probation and there is no conviction, if I'm correct, for this type of argument. I think if she were to be found guilty and her probation revoked, I've reviewed it. If I can rule on it if you want, or I can hold it and then, I mean, the gist of it is that you're saying that trial counsel was ineffective and that her plea was not knowing, voluntarily, and intelligent. Is that correct?
yes, Judge, and in addition that there's an as-applied constitutional challenge in ground one regarding the strict liability. If I may, if this case were to result in a conviction, then that the proper habeas vehicle would be Article 1107. But since it is still a community supervision case as of this morning, the proper vehicle is still 1107-2. And having filed it at this time, I believe that the court's issuing the writ, which the proposed order is on file, is mandatory, and that even if the case were to proceed to an adjudication and even a sentencing today, that the 072 matter would remain open and need to be heard.
Your Honor, may the state be heard?
Yes.
I've talked with our appellate chief, and she's not received any notice of this 11072 writ application. That would be appropriate for the appellate division to see and respond to before there is any testimony or argument regarding that application.
So I just received this morning. We're set for sentencing today. What I'm going to do is hold that writ. I'm not going to rule on it. I'm going to give the state time to prepare for any writ. I will have our counsel take a look at it as well. And if at that point I require any affidavits or testimony, we'll get it set for the appropriate hearing at that time.
Okay, thanks, Judge. The only other housekeeping matter is, and I have a paper copy if the court would like, the order issuing the writ of habeas corpus is a mandatory. It doesn't create any relief or anything. It's just that is the mandatory statutory provision to begin the process. And I would ask the court to.
I'm not going to sign that today. Again, I'm going to take a look at it when I have more time before I sign any order that I haven't had an opportunity to review the entire writ. Look at it with my counsel that works for the courts before I sign anything. So again, I'm going to hold that. I'm not going to start any process at this point. It was filed today, just a couple hours before the hearing. So I don't think it's something that I've been in court all morning. I haven't had a time to take a look at. Ms. French has not either. And so again, that's going to be just on hold. I'm not taking that up at this time.
Your Honor, may I be heard on one more matter?
Yes.
I was in court at 9 o'clock this morning for docket, and sometime maybe around 10:30, 10:20, I happened to look at my email on my cell phone to find that there's a motion to compel discovery and for in-camera review of the state's file. And the only thing that I would like to address regarding this motion at this time is that it refers specifically to the 11.072 motion and appears to suggest that the state has not complied with discovery. And this is a motion to revoke probation. I did provide discovery to the defense counsel on the motion to revoke, as well as the administrative hearing, which I'm not generally required to do, but I do to be helpful. And also the pre-sentence investigation report. So I would also like time to respond to this motion to compel. As I said, I just briefly skimmed it, but those items stood out.
Well, based on the state's, I guess what I don't understand, Mr. Bynum, is why this is being filed today. We're here for a hearing. We're going forward with sentencing today. Ms. French has represented to the court that she has provided discovery with regard to the motion to revoke, which is what we're here for today. There's already been a plea on that underlying offense, and so we're going forward with the motion to revoke hearing on sentencing at this time. I'm not going to sign or grant any motion to compel. It sounds like they have already complied with everything they're required to do, plus some, to give you whatever information you need with regard to going forward with this hearing. So we're going to go forward.
Could I be heard about that, Judge?
Yes.
So the argument in the motion to compel is twofold, right? And I can tell the court, like, since it's an unadjudicated case, I believe that the standard discovery rules apply, and discovery is not limited to just the administrative documents and the matters regarding the motion to adjudicate guilt or the motion to revoke unadjudicated probation. That, you know, she is here being sentenced on the underlying offense, and I'm asking for discovery regarding the underlying offense, which I still haven't been provided. So my objection to proceeding today would be that on this ground would be that I have not received discovery after a request of the offense that we're here for sentencing, and that I think that the Morton Act requires that. The second fold argument here is that in 11072 habeas matter, which at this point is on file, that I have an additional ground that creates a discovery obligation in the state, since it is an 072 matter, contrasting that to 1107 matters, which have their own kind of scheme to replace.
Here's what we're not going to do. We're not going to go forward again on any 11072 matter today, or anything that was filed 2 hours before the hearing. And so we're going forward. You've been provided the updated pre-sentence report. It sounds like you were provided the original pre-sentence report, as well as administrative hearing and other information that Ms. French is relying on with regard to the hearing that we're here for today. The pre-sentence report that you received from before does have the police and court version. It has the defendant's version. It has a statement of interested parties. So you have already some of that information, in addition to, obviously, I'm sure, visiting with your client. So at this time, we're going to go forward. Ms. French, you may call your first witness.
Your Honor, may I respond to one thing to
Sure.
give court notice of? In 2016, Councilman Audwin Samuel, not Councilman, Counsel Audwin Samuel was the attorney for Ms.
It was
Magruder.
actually Mr. Sean Samuel.
Oh, Sean Samuel. I'm
That's
sorry.
fine.
I saw Samuel very quickly. Sean Samuel was the attorney for Ms. Magruder. And I did check to see that he received the media in this case and signed for it. And while I did not have time to also search for an email stating that he had received discovery in 2016, which doesn't show on our current system, the state would point out that she did have the benefit of counsel who did receive discovery under 3914 in the original case. Now, I do understand that Mr. Bynum is trying to make law on this 10-year-old plea of guilt and deferred adjudication order. I would feel more comfortable, Your Honor, if we address these things before we have a sentencing hearing, but I'll do what the court would like to do. I feel there are allegations that should be responded to by historical document. I'm also guessing that somewhere in the court's file of this matter, there is a discovery certificate showing discovery was given under 3914 in the original case. And that would be important to note. I'd like to be able to gather certified copies of those documents in a written response to these motions.
Just a minute. Because this plea was taken before we had our current system, I'll have to look and see. We had those certifications like we do now. I mean, they certified during the plea. That All right, so here's what we're going to do. Ms. French, I don't disagree. I want to give you time to make sure, and obviously time for me to make sure that there's nothing that we do today that would get us reversed and us be right back here. So I'm going to reset the case. I'll give you guys a date. Ms. Holmes will send that date out. I'll take a look at everything and then we'll go forward in just a few weeks on that. All right, Ms. Magruder, you can go back with the bailiff. And I'm also, once you get that date, for the hearing, I'm going to order at this time that any motions that either of you feel necessary to file must be filed 7 days prior to that sentencing date or hearing date, whatever it is. There will be nothing that's taken up that is not filed 7 days prior to that court date. All right.
And Judge, could I just tell the court I'll make whatever accommodations I can, except the last 2 weeks of May. I have some inflexible travel.
If you'll just make sure that you have filed a vacation letter with Jefferson County. So when Ms. Holmes does the reset, that should pop up and she'll see it. Otherwise, there's nothing I can do. So make sure you get that filed today. All right, Ms. Magruder, you can go back with the bailiff.